So this is a discussion about notes on bills that declare what existing law is. As we near the end of a legislative session, we tend to see bills that claim to make changes to statutes and deem those amendments as declaratory of existing law. So how is that done, and how do California courts generally treat those legislative proclamations? Now, to begin, in most instances, of course, legislation applies prospectively, and that is the assumption that we presume in statutory construction, meaning that after the law has been enacted, signed into law by the governor, it takes effect thereafter and applies to conduct or actions that take place after the law has taken effect. Nonetheless, there are times when the legislature does desire statutes to be applied retroactively. Other times they even specify a prospective application date. So here's an example of specific language that's contained in a prior bill intending it to apply retroactively. It says, the requirement to provide COVID-19 supplemental paid sick leave as set forth in this section shall take effect 10 days after the date of enactment of this section, at which time the requirement shall apply retroactively to January 1st, 2021. Another approach used on occasion is an example where the legislature states its intent that a court apply the law retroactively. For example, it is the intent of the legislature that a court interpret this section as amended by the act adding this subdivision in a manner consistent with the interpretation of this section as it read prior to January 1, 2013. And in some unique circumstances, we might have these declaratory of existing law statements. For example, the amendments to this subdivision made by Section 11 of Chapter 256 of the Statutes of 2021 do not constitute a change in, but are declaratory of existing law. Now, is this statement just declaring it? Is I, From my perspective, I don't think so, because I think it's susceptible to legal or judicial challenge. And that's because I think that the legislature actually needs to explain for a reviewing court why the amendatory language should be applied retroactively. So, how could the statement I just read be strengthened and make it more likely to be acceptable to the courts in the state? Well, three suggestions I have. One, right after the declaratory statement where it says, do not constitute a change in, but are declaratory of existing law, explain why the amendment or amendments to the earlier statute do not change existing law, but simply clarify it. Second, add some legislative findings and declarations, maybe even a statement of legislative intent. Usually we find these in Section 1 of the bill, most often uncodified, but you could codify it in this instance. And these statements should explain in detail why the amendment or amendments to an existing statute are not changing the existing law. And then third, I believe that the Assembly and Senate floor analyses should also describe in detail the intended retroactive application of the law change. These floor analyses are communicated to the legislature as a whole, which is the guiding principle in our state courts in citing persuasive legislative history when reviewing a California statute.